Hey everyone, Harry here to talk about a decision by the Court of Appeals, right under the Supreme Court, not to grant emergency relief to the Department of Justice, the United States, in its efforts to revoke birthright citizenship. So, a quick preamble here. You're probably heard tell of it. But the effort that the Trump administration is undertaking seems to be directly counter to the constitutional text. The 14th Amendment says in its very first sentence, if you're born here, you're a citizen, and they have a very far-fetched kind of tortured argument to try to say why you are not. That argument failed in the district court, which enjoined the government from doing anything to try to implement it. And they went, that was by a Reagan appointee, a Republican. They went up to the Ninth Circuit, which had a panel, a motions panel, because that's how these emergency efforts work, of three. Two Republican appointees, a Trump appointee, and it's a very encouraging decision, even though it's a sort of narrow one just about procedure. So the reason it's not a write home and drop the banner kind of decision is because the administration's position here is so tenuous and really feels, I think, to me, DOA, even so much that you could see it in an overall, it's the Matt Gaetz of the litigation strategy, a sort of sacrificial lamb that is going to go down. And should go down. But that said, the Ninth Circuit handled it very sensibly and very methodically. And here's what I mean. First, the opinion comes out from the three saying, you haven't shown an emergency here. You haven't shown, you're asking for emergency relief. And that it's special to get emergency relief. This comes up again and again. It happened in Trump 1.0. It's happened now in the Supreme Court in the administration's efforts to sack the special counsel, Hampton Dellinger, and it happened here in the Ninth Circuit. Oh, we must have a ruling right away because it's just terrible what's going on and we're suffering irreparable injury and we're likely to win on the merits. Well, no. And if you take seriously the standards for emergency, as this court did, it's a really easy case. One, you haven't shown you're likely to win on the merits. In fact, I think most people would say you're likely to lose on the merits. But more than that, you haven't shown there's a special justification for this fire drill that you are imposing on us because, in the Dellinger case, say, they've made an argument that the president really needs to have his people in place as he's gearing up, and a 14-day pause is irreparable injury. Supreme Court might even bite on that argument. But here, there's nothing. And what I really want to point to is the concurring opinion. Everyone agrees. But then in addition, Judge Forrest, a Trump appointee, goes through the effort of a special opinion saying why this really doesn't work. So first, she says granting relief on an emergency basis is the exception, not the rule. It's a principle that the courts would do well to remember because so often the Trump administration comes in screaming and talking about, we must have relief and right away. And so first, you have a really high showing for it, and they haven't made it at all. The only thing they've said, says the Judge Forrest, is the district court has stymied the implementation of an executive branch policy nationwide for almost 3 weeks. So what? That happens anytime people sue, as they always do, certainly in the United States, to put executive branch or legislative branch policy on hold. That's not a justification for this screaming fire drill, stop the music, and issue some kind of emergency relief. Second, you've got to show irreparable harm within 21 days. It's related, but where is the argument that somehow the country or the administration is suffering irreparable harm if they can't effectuate this complete reversal of longstanding 14th Amendment jurisprudence in 21 days? Remember, when you make an emergency motion, the alternative is always, we'll deny the motion and then we'll have a trial on the merits, but we're not going to right now go to the really extreme step of stopping everything, freezing the linebackers, unless there's, it's really likely you're going to win and you're going to suffer irreparable injury if we don't do it that way. And I just want to continue. It's a really laudable, sensible, level-headed opinion about emergency orders from a Trump appointee. She goes on to say, I'm not saying anything about how to properly interpret the 14th Amendment, other than they haven't made a showing that they're likely going to win. But the way it should happen is you assign it to a merits panel. They're an emergency panel. They're for motions because the fires are burning and you've got to put them out. And they're not suited to make these kinds of determinations. We see this in the Supreme Court, where the court has issued really important opinions on the basis of emergency motions, but you don't have full briefing, you don't have oral argument, you don't have thoughtful consideration within the legal community. It's just, and they change things. That should be really the exception and not the rule. And there's a concern that the Supreme Court will be solicitous enough to make it the rule, not the exception. Then finally, and I'm really impressed with this opinion, the judge says there are prudential reasons, not just you haven't made the showing under the law, but look, under the decision of a motions panel isn't binding on the future merits panel. That comes up especially in a court of appeals as opposed to the Supreme Court. What 5 justices say in emergency or otherwise goes, but it's not going to be a full resolution of the issue in the same way. Second, we're a motions panel, and I, made this point already. We're not well suited to do this kind of attention to merits issues. There's a reason that you have briefs and replies and responses and oral argument, and you think about it and go through it, and to preempt all that, you really need the special reasons. And then finally, and this is, I think, a great point, quick decision-making erodes public confidence. Judges are charged to reach their decisions apart from ideology or political preference. Again, a Trump judge writing, when we decide issues of significant public importance and political controversy, hours after we finished reading the final brief, we should not be surprised if the public questions whether we are politicians in disguise. That's right. We should not be surprised. And really, win or lose, so many of the kind of emergency actions that the Supreme Court has taken in the Trump era have contributed to public confidence. Judges are supposed to think things through thoroughly, methodically, with good reasons on both sides. And when it comes up like this, and in 36 hours, they issue a decision, and that's happened, starting with Bush v. Gore. Okay, if you can find a super duper emergency, but let's not kid ourselves. This has a lot of problems, and one of them, and she's right, and it's really important that it erodes public confidence. So I think that statement from a Trump judge, knowing that we're going to have the same kind of panicked fire drill, sky is falling motions from the administration, is a really sort of valuable planting of a flag. And we'll see if the Trump administration now goes screaming to the Supreme Court. I don't think they will, because among other reasons, I don't think they think they're really going to win this. but they really don't have any kind of case to make that this is an emergency and irreparable injury and the like. And while there are 2 or 3 justices up there who would apparently agree with any cockamamie claim, including of emergency, that the administration will make, I don't think they get to 5, and therefore they would be rebuffed. And in general, to the extent we all, and of course the courts, take seriously the notion of the important distinction between emergency relief and action, and what courts do methodically, thoughtfully, with arguments on both sides and the like. That's a really important distinction to really try to carry through and take seriously in this age of Trump 2.0, where everything's a screaming emergency. So very good opinion for that reason, even though it's a kind of not a heavy lift or a surprise to say they haven't made the showing for emergency relief, and probably even they'll probably lose it on the merits. But the basic strike for thoughtfulness and deliberation rather than emergency determinations is a important one. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.